This past week marked a controversial Supreme Court, I should say another controversial Supreme Court decision. The High Court lifted the injunction issued by a lower court, which had blocked the mass layoffs of nearly 1,400 Department of Education employees, effectively allowing the White House to continue to dismantle the Department of Education while legal challenges continue in lower courts, sparking intense debate over the limits of presidential power. So how does this move tie into the broader idea of Unitary Executive Theory, a constitutional interpretation that has gained growing traction in recent years? Can the president really unilaterally dismantle an entire federal department created by Congress? And what does this mean for the future of checks and balances? To tell us more and help us to better understand all of this is David Froomkin, who is an assistant professor of law at the University of Houston Law Center. David, welcome to the program.
Thank you for having me.
In preparing this script, I'm hoping I got all the nuance right of what actually happened. I've seen a lot of reporting that basically just says, oh, they killed the Department of Education. But that's not exactly what happened. It's not exactly what the Supreme Court said. But effectively, it does lead down that path. Help us explain.
That's right. So this was a preliminary decision, a decision to lift a stay that the district court had imposed that blocked the Department of Education from firing over 1,000 employees. That said, the administration has announced its intention more broadly to dismantle the Department of Education, saying that this was the first step toward that goal. So I think that the majority probably would prefer to characterize this as a procedural decision, merely about the preliminary injunction, but it's likely that it will have much more sweeping effects.
In realistic practice, what's happening then is that these folks were laid off. It's a massive amount of employees for this department, and that in the time it takes things to move through the court, that dismantling, in effect, destroys the Department of Education even before the final courts have been ruled. And if the courts come back and say it can't be done, the cow's out of the barn.
It's very hard to build state capacity. It's very easy to destroy it. And once these officials are fired, they're not going to wait around hoping that they'll be reinstated in a year. They're going to look for other jobs. And it's going to be very difficult to rebuild what the department is destroying today.
So 1,000 employees is what percentage?
It is a substantial percentage. I mean, we're talking about at least 50% of the...
So 1,000 of 2,000 employees, basically.
Well, I don't recall the exact number, but it's more
close.
than 1,500 employees.
David, there are some people that could say, and this is, I voted for the president because I wanted change. I wanted this type of dismantling. We have heard, I think a lot of people can look to our government and there is a lot of bloat. There is a lot of ineffectiveness in different agencies. But whenever you completely dismantle, and you're saying that it's going to be very hard for you to rebuild, but could it be that they're going to rebuild it in a more effective way? Or is it really this will be a major issue?
I have to reject the premise of the question. I don't think it's true that there's a lot of bloat in government. The government operates much more efficiently than most private organizations.
Well, I mean, I would actually...
Well, it was the cell, right?
I was going to say, I also I disagree in that I think a lot of people look at our government. I think that's also a political standpoint, but a lot of times when you look at, we have had experts on Hello Houston that are even looking at FEMA, which is such a hot topic right now, that says that it's not always effective and it takes a very long time to push forward what they are trying to execute on. And so when we're looking at this, there's a reason why that, whether you like it or not, the president implemented DOGE. And I'm sitting here as somebody who works for one of those organizations that could potentially feel the effects of DOGE.
The government exists to solve big problems that no other organization in society is going to solve. And often the problems are big and solving them is hard. And so the solutions don't happen overnight. But preventing the government from being in a position to tackle those problems doesn't mean that they're going to be solved more effectively. It means that no one, in most cases, is going to be tackling them. And when it comes to environmental protection, public health, consumer protection, protection of students,
And I'm not saying that those things are not needed. However, I am saying that when we're looking at organizations, that we look at kind of that ineffective, again, I have to use that word bloat because I think that's what a lot of people felt that the president was going to do.
But I think the bigger issue at hand here, and help me with this one, is that the question at the center of all of this is, does the executive seat have the right to dismantle an organization that was set in effect by Congress, which then leads us to the Unitary Executive Theory. And that's where we have to start. And I think that's what the Supreme Court is looking at and what court watchers are looking at and government theorists are looking at.
That's right. So I study the separation of powers, and to me, that is where this decision has the most significant stakes. I think that this is potentially the most radical, far-reaching decision affecting the structure of government, the separation of powers in modern history, because the administration is taking the position that the president has the authority to nullify laws passed by Congress. Congress said there has to be a Department of Education. It has to perform certain functions. The administration has taken the view that they don't have to comply with those orders from Congress. And the court seems to be backing them up.
Yeah, but I don't know if you saw the line that Trump wanted to get rid of FEMA because he said this money should come through the office of the president. The president should decide who gets help when there's a disaster. And then the implication is the red states are going to get the help they need and the blue states are not. And if you didn't have a blue governor, you'd get some help. So make sure you get a red governor and then we'll help you. That's what happens when you dismantle these agencies and their ability to put funds out there and you want to do it all yourself. So you say, well, I don't like the way that state is handling their education. So until you handle it the way I want you to, you're not going to get any money.
And if that were to happen, that would be the end of the rule of law. And
absolutely.
What the rule of law means is
that's a lot of people say it's going to
equally.
happen. There's a lot of fear that that's where this is going.
That is the danger. That's certainly the danger. And it's a reason why we want governance to occur through routinized procedures that treat people consistently and fairly before the law. That is really what's on the chopping block.
So if you get rid of the bloat, fine, I'm all for that. But if you get rid of the bloat, you still have to show us who has the authority and not just one person.
And what we're seeing is an assertion of a sweeping change in who wields authority in our constitutional system, a change that would have been news to the framers, I can tell you that, who did not see the president in the way that proponents of the Unitary Executive Theory today see the president.
The issue at hand that got us talking about this is the Education Department and at this point, the Supreme Court in this particular case has not said that the president has this authority. Have there been cases in this administration or previous which has pushed more toward the president having that authority, or are we still in that gray area approaching it and haven't heard it yet?
So there has been a growth of the Unitary Executive Theory in recent years under the Roberts Court. I think it's important to emphasize how novel all of this is. Right. The Unitary Executive Theory really was created about 40 years ago and was not a view that people subscribed to before then. Indeed, it was a fringe minority position when it was first advanced in the 80s. And the idea that it is a core principle of our constitutional order today is a very novel and radical innovation in our constitutional system, and in fact, one that really throws out the design that the framers implemented.
They look at Article 2. I'm sorry, I just want to clarify. And what, if you can give me the wording exactly of what is in Article 2, which is where we're looking to understand what are these powers.
So the theory rests on one phrase in the first sentence of Article 2, which says that the executive power shall be vested in the president. That's all. So
Then
there's an idea of what it means
balances,
to have executive power, and a lot gets built into
the argument of checks and balances is that if you're going in the direction of the president having more power, is that checks and balances are for the Congress, not for the president. Is there anything that supports that in the Constitution?
Absolutely. Well, so the principle of separation of powers is that one actor, Congress, makes the rules, and a separate actor, the executive branch, implements the rules. If you have the same actor, the executive branch, making the rules and implementing the rules, you don't have the separation of powers.
And that's what's happening.
That's exactly what's happening.
You're listening to Hello Houston. We're speaking with David Froomkin, Assistant Professor of Law at the University of Houston Law Center. You can join the conversation at 440-8870. We have a call on the line right now. James from the Woodlands. James, welcome to Hello Houston. What is your comment or question for David?
Hi there. I will try to be brief. Okay, so you all were talking about Doge in with this subject. The real savings is Medicare, negotiating drug prices, and defense contracting. But yet those things were overlooked, and now wiping out and cutting employees, all of a sudden that's waste. Well, those two places definitely have waste. Okay, what this administration wants to do is have states control education to where this country turns into a white nationalist Christian nation where the children will be indoctrinated to think that way. That's the only way they can survive. They can't survive on ideas. They have to survive on indoctrination. And I would like to hear his comment. By the way, I don't like the Supreme Court putting a thumb on the scale of their rulings in favor of Donald Trump.
James,
Thank you,
thank you for
James.
your comments.
So what do you think? You dismantle education, you control education. Like I said, if you're not doing it the way I want you to do it, you're not going to get any money because I control now the Department of Education. So what are your thoughts on that? Is it all toward indoctrinating our kids to think a certain way?
Well, we've certainly seen that happening at the local level in recent years with school boards trying to assert more control over what books are permitted in schools and classrooms. I think it is scary to see it moving to the federal level. Obviously, the federal government is much more powerful in principle, has the ability to impose those rules on jurisdictions that wouldn't implement them at the local level. And I think it's too early to say, but there's certainly danger here.
If you're reading the tea leaves, and it seems as though that the court is going toward more power to the executive branch, can they do something to pull it back? Theoretically, they're supposed to be approving the dismantling of these organizations, yet there seems silent on it. Is there some way they can get involved and pull it away from it just being the judiciary at this point?
I think the really important thing to understand is that the separation of powers as it was conventionally understood has collapsed. We have an executive branch that is ruling effectively without congressional oversight or authorization.
Right.
And I think that what that means is that Congress's formal power to impose legal instruments constraining executive action is in decline. That said, there is an important rhetorical battle to have. Congress can assert authority, can assert its prestige. And that's why I think that the way that the Supreme Court is behaving is so damaging, so dangerous to our republic.
And it only took 5 months.
But you use the word collapse. I mean, I can understand that there is essentially, we're looking at potentially corrosion. And we understand that when we were going into this election, one of the number one concerns for voting Democrats and why they were extremely concerned was about our democracy. But we still have, our three branches of government. We are seeing now interpretations of the Constitution. But so far, from what we understand from legal experts that we've had on our show, there actually hasn't been anything illegally happening. So I don't know if collapse.
They've said that nothing that has happened since January 2025 was illegal. I would say a substantial proportion of what the executive branch has done since January 2025 has been flatly illegal and unconstitutional.
So then why is it happening? Because the courts are on their side?
The Supreme Court on many occasions has blocked the efforts of lower courts to rein in a rogue executive branch.
And that continues to happen.
And the McMahon decision permitting the dismantling of the Department of Education is just the latest example.
Does it frighten you, as I said earlier, 5 months? It's all only taken 5 months.
It does frighten me. And I think one thing that's important to recognize is that for a lot of institutions, when there is a rising tide of authoritarianism in a system of governance, a lot of institutions continue to operate as usual. Their operations are not perceptibly affected. And it may be easy for them to say there's nothing too abnormal going on here. But elsewhere in the polity, there are things that are really unusual, unprecedented, and dangerous, and we should be attuned to those.
David Froomkin is an assistant professor of law at the University of Houston Law Center. David, thanks for joining us today.
Thanks for having me.